This is about foreclosure in California as it relates to second deeds of trust. Most second deeds of trust or home equity lines of credit, also called HELOCs, are remnants of the 80-20 loans that were prevalent during the run-up to the mortgage crisis. These are also known as piggyback loans. These piggyback loans were low-cost loans with very little or no money down, which included a first deed of trust for 80% of the loan-to-value and a second loan for 20% of the loan-to-value. So basically, you're over-borrowing right from the beginning. And as the mortgage market imploded, the value of the security went below the amount of the first deed of trust. So the second deeds of trust were quickly unsecured. And what that meant is that people stopped paying them. Right? This will sound very familiar to a lot of you, okay? So just because you stopped paying it, because at the time the house didn't have the value, the loan didn't go away. In fact, it was sold to an investor. Then years later, around 2010 to 2015, when servicers were modifying these first deeds of trust, they would trick borrowers into thinking that the seconds were included in the modification, or tell them the debt was written off or forgiven or charged off. Those are terms that they use. But still, the loans never went away. They might have been charged off of that bank's books, but they never went away. They were just sold to somebody else. They went to a secondary market. Now, the reason that servicers lie about this is to avoid tipping you off that you still owe this money. Because if they tell you the truth, then you might figure out that you can fix it. Like you might go to an attorney, get some advice, and realize that there's a simple way to do a bankruptcy and strip off a lien that is unsecured. You can do it through a lien strip in a Chapter 13. The lie was among all the banks and investors to purchase these loans and would then hold them until equity came back in the property, at which time they would foreclose. Now, we're getting a lot of you coming in with these second deeds of trust foreclosing because the equity has come back to all your properties. Unfortunately, the foreclosure statutes were developed to protect borrowers against the actions of unscrupulous servicers. Do not include these seconds. Unless you can prove that you tried to pay them and that you were not permitted to, there's no repercussion to them if they foreclose. So no use arguing with them that they're not entitled to their interest. They are entitled to it. If the servicer of the second has lured you into applying for a modification, this is also only to trick you into foreclosure, because these seconds are settled, but rarely are they modified. The statutes don't even require the servicer of these seconds to give you any advance notice before they record a notice of default and begin foreclosure. There's very little protection around these seconds. It shocks people when they realize that the holder of the second deed of trust they thought went away is now foreclosing on them for the full amount of the debt plus interest. Something that was maybe $75,000 when you borrowed it is now $275,000, and there goes all your equity. As property values have gone up, the holders of these seconds have waited longer and longer, letting their interest accrue because they know they will get it back when they foreclose. Basically, they're sitting on money. And if you manage to modify your first deed of trust and maybe got a principal reduction, this is all money that will now go into the pocket of the holder of your second. So the bottom line here is, if you have a second that remains secured by your property, settle it, or find the beneficiary and start paying it. And if you need help negotiating this, hire an attorney to represent you.